the things that we're learning, Sarah, as we're walking through a lot of these state cases against Trump, state laws are pretty pro-prosecution.
I know.
Like if you look at the Georgia RICO statute, that's a pretty freaking pro-prosecution statute. This one, pretty pro-prosecution. I don't know if it's as pro-prosecution as Bragg is making it, but it's pretty pro-prosecution.
I gave this example in the collision, and I think it's helpful for some people. It'd be odd if the law punished someone only if they themselves knew what specific crimes they had committed. A mob boss who tells his secretary to write business lunch instead of cement and buckets in the books isn't innocent just because he doesn't know whether he's covering up first-degree murder or manslaughter. So again, like Trump might have just been like, yeah, I don't know, this is probably pretty shady, and I definitely don't want like the FBI being able to see that I paid this hush money. So just like, don't write that it was hush money. And like, I don't know, who knows whether it's a tax crime or a federal election crime.
Right.
Like it just feels crimey to me. And so I want to cover it up. That would meet the standard here. Now, I think, of course, the biggest problem with this case is that they did not really have any evidence of Trump directing or causing to be made that false entry. So even if you accept that it is a false entry to write legal services, and I think there was decent evidence around that.
Yeah.
And even if you accept that sort of the purpose was to conceal these other potential crimes, you still have to prove that Trump's the one who told them to write legal services. And they just really didn't have any testimony to that because the person who does the books, Weisselberg, didn't testify. His sort of that coterie around him didn't testify. You have Cohen saying he thinks that's probably what happened. That should not be enough, really. But juries are allowed to make inferences. I think there was enough evidence as a matter of law on that element, but actually I think that was a close call even as a matter of law.
Yeah, I still keep, and look, I just want to say this again. We're recording this before there's a verdict. The jury is now deliberating into day 2. We'll refrain from speculating as to what that means. But I've said this before, I'll keep saying it. While it is quite possible that he's acquitted, and a lot of people are underestimating, I think, the chances of acquittal. While it is quite possible that he's acquitted, it's also quite possible that he's convicted. We have the election. He might lose it narrowly and then have the conviction overturned on appeal, which I'm not predicting that as a definite outcome, but it is a very possible outcome. It might even be rise to the level of a likely outcome, but it's certainly a very possible outcome. And Sarah, that really bothers me. This idea that we could have a criminal conviction, an election, and then a reversal of that criminal conviction. That really bothers me for reasons that I think should be obvious.
Well, we'll leave it there. And for our next episode, if we have a verdict, obviously we'll be talking about that. But regardless, David, the Hunter Biden gun charges case starts. He's facing 3 felony counts in a federal courthouse in Delaware. And so we'll do a deep dive. I've gone through the federal sentencing guidelines, what he's facing, what would happen if his name wasn't Hunter Biden, all of that and more on the next Advisory Opinions.